All right, ladies and gentlemen, I have about 9 o'clock. I'm going to call the dockets. I'll ask for announcements from attorneys. Anyone who's present who doesn't have an attorney, or if your attorney doesn't answer for you, let me know that you're here. Other than that, please keep your electronic device muted. And I'm going to go ahead and make Ms. Poppy the host, ask her to make me the co-host. All right, on the criminal side, State versus Gary Wilshire.
He is in custody, Your Honor.
You go and look at Wilson County Indigent Defense.
You gotta unplug it too when you do it. That's it? Well, I get it, I got it.
Well, I see we finally have some folks in the queue for Wilson County, but Mr. Wilshire is not one of them. Ask Public Defender's Office to get with him. State versus Mary Lily Amezquita.
Council President, this is one of my former private clients, Judge, and I believe she's in custody.
Yes, she is.
All right, and I'm having computer problems this morning. I've already rebooted once and it's just barely working. So bear with me. State versus Joseph Padilla.
Your Honor, Lisa Boyd, I'm present for him. I didn't realize this case had circled back to the docket.
And Lisa is previous appointment, Your Honor. This is an MTR, and so he needs a new appointment, and he is in custody.
And again, I have no financial information on him. Public Defender's Office to get with him. State versus Isenia Sotelo.
Your Honor, I'm present for her. She's currently in custody and we'd like to continue to confer. This is Kathy Starling.
Have you been appointed to her previously?
Yes, Your Honor. I'm not sure that I got appointed to all the cases because she has 3 MTRs on 3 separate causes, but I was appointed to at least one of them on the last docket, and so I made an assumption I was appointed to all of them, but I only saw one appointment.
Okay, and she's someone I do have a financial voucher for, so I will appoint your office.
Thank you.
Actually, she's got 2 cases. I only have 1 voucher. I'll appoint you on everything. State versus Casey Dwayne Ferris.
Your Honor, that one is also mine. I would like to confer briefly with the state this morning, and then I think we're going to have a hearing on that.
And he is in custody.
Custody. Isenia Sotelo, okay, so we got all 3 of them. Mary Lily Amezquita is still in custody. State versus Vicente Avila.
Judge, I'm here for him. I received a notice from his family that he was arrested on a warrant yesterday, and I'm not sure if that's out of this court or if it's a new warrant.
I do not show him in custody here in Wilson County, and I did not show a active warrant on him either.
It says warrant recall. I don't know if that.
Yeah, right. It should have been recalled. So they were wondering why.
Where was he supposed to have been arrested?
I received email this morning that he was arrested yesterday.
Where?
Oh, let's see. I thought it was here, but I don't think it said.
Well, check on that, please.
Will do.
All right, State versus Kevin Lopez. Kevin Lopez,
I have contacted him previously.
he's logging
and-
in right now.
What's
I'll
that?
mark you confirm.
All right,
He's
thank
logging in right now. I'll mark you confirm.
Thank you.
I hope. All right, Wilbert Maldonado.
Your Honor, I talked to him about 15 minutes ago. Yeah, there he is. He's present, Your Honor.
And do we have an interpreter?
No, Your Honor, we're gonna have to reset. I'm talking to the state. We had a motion to suppress, and there was an offer and he can't take it.
Okay. Poppy has already posted the reset dates. Haley Gibbons.
Good morning, Your Honor. Council's present. I believe she should be on. I just cut off the phone with her. If not, she's signing the plea paperwork documents and should be on shortly. And I'll be getting those to the court whenever I get them.
Rolando, is she going to be at probation? She has to be present.
I told her to be at probation to let me give her a call back so she can be there.
Thank you.
Yes, ma'am.
Okay, and we have a telephone number, a 210 area code that ends in 726. Who is that? Yes, your name?
Yes, this is Haley,
All right.
Your Honor.
Okay, and you heard what your attorney said, you have to be at the probation office?
Was that for today?
Yes, ma'am. Remember I told you yesterday that if you're going to take the plea, you had to be at the probation office?
Yes,
So get to the probation office.
Thank you, Judge.
State versus Jose Barrientos.
Your Honor, he's here in our lobby. And we had Michael Baird on another case of his. So we probably need to see about appointing Mr. Baird on this one as well. But Mr. Baird did not know to be here because he didn't have anything on the docket today.
All right, I will appoint Mr. Baird. If we can get a reset date for Mr. Barrientos to sign for when Michael Baird's supposed to be here. State versus William Bauer.
Your Honor, he is currently in ISF. His projected release date is March 23rd. If we can get a reset date after that, that would be perfect.
Okay, please get with the state. I mean, the coordinator.
Yes, Your Honor.
Wall. No show. Melissa Rich. Vivian Barrera.
Yes, yes, Your Honor, I'm present.
All right, Ms. Barrera, do you have an attorney to represent you in this matter?
No, sir.
Are you able to hire your own attorney?
I'm waiting to get back on that.
Okay, let me rephrase this. Have you ever hired an attorney to represent you in a felony?
No, sir.
Have you spoken to enough attorneys to have a good idea of what it's going to cost you to hire an attorney?
I did speak to one, but he didn't give me like the price range or whatever. But I'm waiting to get an attorney.
She has been interviewed. She is in indigent defense.
Okay, and I see that you're eligible. Ma'am, I will appoint a court-appointed attorney for you today.
Okay.
And if you hire a family comes up with money or something in the future, then that attorney can make an appearance. All right.
Okay.
State versus Joanna Rodriguez. I see Melissa Rich is in indigent defense queue in my appointment queue also. Joanna Rodriguez. No show, Renee Romero. No show. Douglas Shields.
He is in custody, Your Honor, and he has gotten an appointment last week, Roberto Vargas.
Mr. Vargas here. All right, let's check on him. He may not have had notice.
Sir, he didn't have notice, so we would normally reset that to 3:31 for arraignment.
Okay. $3:31, it is. Okay, anyone else told to be here today just on a criminal case? All right, I will dismiss the attorneys for the state and the attorneys in those civil matters in the docket, and give me just a moment. Let me talk to you all about appointments.
And Judge, can we get the Jill to bring Mr. Wilshire over for the interview?
That, or they can do it over in a breakout room.
Yes, that's what I mean. So I can put him in a breakout room.
All right, please.
Wilson County Jail, did y'all hear me?
Yes, ma'am, we did. I'm having him brought up right now.
Thank you, sir.
Okay, and are we certain Melissa Rich is not in custody? I just know that she interviewed with the Public Defender's Office last week. No? Okay. Go to the appointment queue.
I'll go into PID, Your Honor, and make sure she's not there, but I believe she bonded out last week.
Okay. Not for long, maybe. Okay, and is Ruben Flores here? No? Okay, Mr. Cedillos, you are the next attorney up on the next 5 attorneys who's present. So I'm going to appoint you to Vivian Barrera.
That's fine, Your Honor. I can take that.
And Your Honor, I have checked on Melissa Rich. She bonded out right after she had been arrested, just a couple weeks later. So she must have called in to give her interview when she received her letter.
And at that time, they should have been reset to 3:31 if they called in.
All right, so I'll assume that she's not.
Even if they weren't appointed, Jennifer?
No, once they're interviewed, that's what, and after they're appointed, there's a gap there where folks aren't being informed of who their attorney is or their reset date. Probably take that offline, but normally when they get interviewed and assigned an attorney, that's when they get reset to the next date. So they don't have an attorney?
No.
No.
Just
Okay.
has been interviewed only.
Okay, and I've just appointed the Public Defender's Office on Ms. Sotelo on the case that's on the docket, the first case is on the docket. All right, civil cases, Wilson County. Ditech Financial versus Alice Marroquin and other people at 1110 South 2nd Street.
Good morning, Your Honor. Attorney Carlos Hernandez Vivoni on behalf of the plaintiff.
All right, sir. Anyone here on the house on 2nd Street, South 2nd Street?
Yes, Your Honor.
All right, I'll mark you number 1.
Okay.
Alfonso Madrano versus Eagle River Energy.
Morning, Your Honor. Adam Anthony here for plaintiff.
Chris Allison here for the defendants, Arias and Eagle River.
Okay, and I'm sorry, Chris Allison. All right, who else is here? Is that it?
Adam Anthony for plaintiff. And
I'm
that's
on the
just
defense.
Your Honor, just us two.
Okay, and what do we have to hear this morning?
We have a motion to quash and motion for protective order filed by a plaintiff.
All right, and how long to hear that?
15 minutes.
Yeah, I agree.
Okay. All right, I'm going to ask the two of you right now to confer in a breakout room, and if you're not able to resolve that, then we'll come back and hear it pretty quickly. Ovation Services LLC versus Stephen Rose.
Morning, Your Honor. Nacio Barreto for the plaintiff.
Good morning, Your Honor. Jeff Garcia on behalf of the intervener taxing entities. We announce ready.
We're ready to, Your Honor.
Okay, and what is this we have to hear this morning?
Your Honor, this is a trial. We're trying for a judgment for delinquent taxes, foreclosure, and for tax liens in order of sale.
And how long to hear that?
Well, myself and the intervener are aligned. I don't know if Mr. Rose is here. If he's not here, 5 minutes.
All right, I'll mark you number 2. In the matter of the marriage of Clarissa and Jeremy Flores.
I'm present, Your Honor. Oops.
All right.
Present, Your Honor.
And are you ready to proceed, ma'am?
Yes, sir.
Okay, I will mark you A. You'll be the first self-represented case that I call up. I take up the uncontested matters with attorneys before without attorneys.
Thank you, sir.
The matter of the marriage of Yolanda and Sydney Maxwell.
Judge, we had a Rule 11 filed this morning. It's a Rule 11 on temporary orders. So their next setting is for the merits on June 7th.
Is that for the protective order also?
Yes, sir.
All right. In Ray Daniel Ramirez.
Morning, Your Honor. Counsel's present. That is a bond reduction hearing that we have scheduled for this morning.
Okay, how long to hear that?
I just have one witness, maybe 15, 20 minutes at most.
Okay.
We agree, Your Honor.
All right, I'll mark you 15 minutes and conferring. And is anyone else told to be here today on a criminal case? Your case was not called? No? Okay.
Excuse me, Judge, may I make an announcement?
Yes.
On Ms. Gibbons' case, she's ready to take the plea, but she does live in Bernie area. She's going to start driving down. So I was going to ask the court, what's the latest that we can do the plea?
I will be here all morning. I'll keep it open.
Okay, thank you, Judge. Then I'll be here.
All right, let me grab the files called Ditech Financial versus Marquine first. 1710.
May I address the court, Your Honor?
Yes, give me just a moment to look at the file.
Yes, of course.
Can the Wilson County Jail please join breakout room 1? And Miss Whitney, I just invited you to breakout room 3.
All right, go ahead, sir.
Yes, Your Honor, this is Attorney Carlos Hernandez Vivoni on behalf of the plaintiff, Ditech Financial. Your Honor, in this case, we filed our petition back in 2017. The defendant appeared and filed an answer, not contesting the allegations. Motion for summary judgment has been filed and is pending this hearing, Your Honor. Our motion for summary judgment has attached security agreement, notice of default that was sent when the petition was filed, and an affidavit from a person that has knowledge of the facts as to Ditech. Your Honor, at this point of time, that motion for summary judgment remains uncontested. We understand that all conditions precedent are included in the court registry, for which we ask the court to take judicial notice of, and we move the discretion of this honorable court for entering summary judgment at this point of time.
All right, I'll take judicial notice of the entire contents of the file, including the fact that there was an answer filed, although it says that he neither admits nor denies anything. I'm not, as a good enough probably for a pro se answer. And there's been no response filed to the motion for summary judgment, so I will grant judgment in favor of the plaintiff. Do I have a proposed order?
Yes, Your Honor, there's a problem with the proposed order. It does not contain the specific numbers, so I will upload a proposed order with the numbers as per requested by this court.
Okay, all right. And if you could, if I'm still on, you can post that in chat. If not, just file it with e-file, it's fine.
I'll do so. Permission to be excused, Your Honor.
Yes, sir, you're excused. All right, Ovation Services versus Rose.
Good morning, Your Honor. Ignacio Barreto for Ovation Services.
Good morning, Your Honor. Jeff Garcia on behalf of the taxing entities.
All right, and give me just a moment. Actually, let me grab that file. It's 20-0. All right, go ahead, sir.
Thank you, Your Honor. On behalf of Ovation Services, we asked the court to take judicial notice of the business records affidavit that we filed, and also the affidavit of attorney's fees.
Let me ask, is this a trial on the merits?
Yes, sir.
Okay, and you gave notice to Mr. Rose?
Yes, sir. He has notice. In fact, this case was called last week. Judge Ellison, when Judge Ellison was on the bench, and unfortunately, we didn't have all the parties there at the time. I think the intervener had already left or something. Anyway, so it was recalled. Mr. Rose was in the courtroom, and the court said that it would be set for today, and he had notice at that time by the court's verbal notice.
All right, go ahead, sir.
At any rate, Your Honor, again, we asked the court to take additional notice of the business records affidavit filed and also the affidavit of attorney's fees, which support our request for judgment in total for Ovation Services in the amount of $12,223.07.
All right, sir. And without objection, I will admit your affidavits and evidence. Anything else on the plaintiff?
No, Your Honor.
Okay. Mr. Garcia?
Good morning, Your Honor. At this time, interveners would like to offer into evidence, which has previously been e-filed, and marked as Exhibit A, which is interveners certified tax statement under the tax code showing delinquent taxes owing and assessed in favor of plaintiffs in the amount of $6,070.62 for tax years 2018 through 2020. We ask that that exhibit be admitted to evidence.
All right, without objection, I'll admit Exhibit A into evidence. And just let me just make sure, Mr. Rose is not outside.
I can check with the bailiffs to call his name if you would like.
Well, let's do that, especially if he was here last week.
Okay.
I'm gonna go check in Judge Ellison's court also.
Judge, there was no answer to the name of Stephen Rose that was called here in our building.
All right, thank you.
He's not mistakenly on the other Zoom either.
Okay, anything else from either side?
No, Your Honor.
All right, I will grant the relief prayed for.
Thank you, Your Honor.
Order. Who is,
I believe an order has been sent to the court.
I just forwarded over to the through e-file this morning, Judge.
okay, I'll check on e-file. Thank you. Y'all are excused. That's all you
Thank
have
you,
to
Your
do.
Honor.
All right, Medrano versus Eagle River. You ready on that?
Yes, Your Honor.
Yes, Your Honor.
Let me pull the file. So it's a motion for protective order and to quash.
Yes, Your Honor.
All right, let me look at the motion real fast. All right, when you say that the defendant lost 2 tires, were they like on the back of a flatbed and fell off, or he had 2 tires separate from his wheels?
He had 2 tire and wheels separate from his trailer, Your Honor.
Ow, okay.
Yeah.
And has there been a response filed?
Yes, Your Honor.
A response and a reply.
All right, go ahead.
Thank you, Your Honor. So we're here on this motion protection. What has occurred is defendants, the motor carrier out of Dallas and then the driver, Ardias, who's from Florida, they're essentially seeking discovery, potentially thousands of documents from a non-party entity, and in defendant's own words, to attempt to prove standard of care. As the court just read in the summary, this is a commercial motor vehicle crash where the driver's back two tires from its trailer came dislodged, flew across the highway, and struck my client's vehicle, causing him to careen off into the side. The defendant's corporate representative has already testified as to what their policies are and what the industry standard of care is in this case. That's how we get to these 21 inspections that the driver and or defendant company were supposed to complete. Defendant only completed 5 of those. I think because defendant doesn't like the corporate representative's testimony on standard of care, they're now trying to seek standard of care discovery from a non-party entity. This non-party entity, discovery to them as to standard of care is completely improper because one, they are not involved in this case. They haven't been sued. They haven't been RTP'd, not even disclosed as an RTP. So the pleadings have nothing to do with Rock and B, who is the non-party entity. Putting that aside, the only reason defendants have expressed for seeking such discovery, potentially thousands of documents, is try to kind of do an end around for their argument of standard of care. They're essentially reaching out to another motor carrier whose only involvement is that they employed plaintiff to try to seek their policies, their procedures on items that relate to Eagle River, the defendant, but do not relate to my client, Mr. Medrano, and his actions in this case. Defendant essentially agrees with that. They say in their motion, hey, we are seeking this discovery to try to prove up standard of care. that is improper in this case. It'd be as if plaintiff was trying to use one other company's policies and procedures to hold liable the defendant company. If we were doing that, if plaintiff was seeking that discovery, defendant motor carrier would have their arms up in the air saying, hey, you can't hold us liable to some other people's policies. You got to look at our own policies or industry standard. One other entity who is unrelated to this case cannot prove standard of care. Therefore, discovery to that entity is completely improper on those grounds. Defendant has sought some other issues such as kind of payroll and things like that. We're not objecting to that. We're allowing that to go forward. It's all the policies and procedures and those issues that we as plaintiff object to, and are asking this court to enter in first to quash the motion, the DWQ, and also enter a protective order as to Rock and B, the motor carrier that is plaintiff's employer and local, that the court would deny defendants discovery to them, which is potentially thousands of documents. Thank you, Your Honor.
All right, so are you objecting to, you said not objecting to payroll information. How about the information about why your client departed employment by his previous employer?
Yeah, so I think that's going to be related to kind of what occurred, Your Honor, was that he was injured, work comp case was filed, and then there's an issue of whether the work comp issue terminated him and or the loss of a contract. If defendant wants discovery into that, plaintiff is okay with the termination issue.
All right. Mr. Allison?
Yes, Your Honor. Just like defendant Arias, plaintiff Medrano was a commercial truck driver driving within the course and scope of his employment with Rock and B at the time of the subject accident. The defendants have pled a claim for contributory negligence in their original answers. As you know, the scope of discovery is broad, and it's anything reasonably calculated to lead to the discovery of admissible evidence. And we think our requests regarding Rock and B's company policies, pre-trip inspections, post-trip inspections, Mr. Medrano's DOT logbooks, and any documents reflecting what pre-trip and post-trip inspections Mr. Medrano completed, those requests are reasonably calculated to lead to the discovery of admissible evidence on our contributory negligence defense. Specifically, they'll shed light on whether Mr. Medrano potentially violated any DOT regulations of his own while he was driving, or whether he violated any of Rock and B's policies during the time of the subject accident. And for that simple reason, we think the information, in addition to the request regarding hiring and termination and payroll, we believe Rock and B's company policies and pre-trip and post-trip inspection records for the subject vehicle are discoverable. They're limited only to the week leading up to the accident, so it's not overbroad in time. And for those reasons, we ask that you deny plaintiff's motion to quash and allow the subpoena to proceed.
And how would the type of policies in place and whether or not plaintiff adhered to them contribute to the separation of two wheels from your client's vehicle?
Well, it would be I agree, those two are unrelated. It would be an unrelated inquiry into whether or not Mr. Medrano committed any separate negligence on his own. He could have violated the hours of service rules that are applicable to DOT, to companies such as Rock and B. Simply we don't know until we get the logbooks and until we get the company policies, what those policies are even were. I think also the company policies are regarding pre-trip inspections, as Mr. Anthony alluded to in his argument, are relevant to the standard of care applicable to companies such as Rock and B and Eagle River. Like there's a dispute on how many pre-trip inspections is required of companies such as this working in the oil field. The plaintiff has alleged that we violated the standard of care by improperly conducting pre-trip inspections. And we want to be able to rebut that claim by saying, clearly, this is what the standard of care requires. Plaintiff's own company requires the exact same things that we do potentially. And therefore, I think that's also relevant and reasonably calculated to lead to the discovery of admissible evidence.
You had it briefly, if I may.
No, I will grant the motion to quash and protective order to everything we've just discussed. I would overrule it to the extent, if any, the plaintiff is still advocating it for anything that has to do with compensation that the plaintiff received and or the reasons for his termination.
Thank you, Your Honor. And if the order doesn't reflect that, we'll make sure it reflects the court's ruling and we'll upload it to chat.
I would add, Your Honor, the order that the plaintiff already submitted does not reflect the court's ruling. It only reflects granting the motion for accident investigation, but not any of the reasons for termination or payroll documents. So I do think we need a new order.
We'll get with.
Okay, if y'all will work on that, and if you have it agreed, post it in chat. If you can't agree to the format, come back.
Okay,
Yes,
thank you.
We'll do.
All right, Mr. Barrera, do you still need a hearing on Daniel Ramirez?
Yes, Your Honor. And I have a witness that I need to call. If you could just give me a heads up as to when the court wants to start, and I can give her a call and get her online.
Okay, as soon as let me go ahead and do the pro se divorce, and then we'll start after that.
Thank you, Judge.
Your Honor, may I interject? I located my client. He is in Bexar County Jail.
Okay, which client is that?
Cnty Avila.
Okay.
So how does the court want to handle this?
Get a date. And I see that Stephen Rose has just appeared.
I'm here, Your Honor.
All right. Mr. Rose, where were you at 9 a.m.?
Oh, shoot, I'm sorry. I forgot about the time difference. I'm sorry.
All right, sir. Okay, I've already finalized this case, but now that you're here, I'm going to ask the coordinator's office or the clerk's office to try and get the attorneys back. What was that, Mr. Ignacio and Mr. Garcia? So let's wait for a minute, please. Let's try to get the attorneys back. All right, calling matter the marriage of Flores. All right, Ms. Flores. And there's a Jeremy F. Is that Texas? Is that Jeremy Flores?
Yes, sir.
Asking your wife to unmute. Somebody will let me know if she comes on. I'm trying to look at the divorce decree online.
I'm sorry, I'm here, Judge.
Okay, give me just a moment. Okay, are both sides ready to begin in the Flores divorce?
Yes, sir.
Yes, sir.
Let me ask you both to raise your right hands. Each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
All right, and you are Jeremy and Clarissa Flores?
Yes, sir.
Yes, sir.
Okay, and put your hands down. Ms. Flores, but before you filed this lawsuit, had you been a resident of Texas for 6 months and of Wilson County for 90 days?
Yes, sir.
And you're married to Jeremy Lorenzo Flores?
Yes, sir.
And has the marriage between the two of you become undermined due to a discord or conflict of personalities?
Yes, sir.
Is there any likelihood the two of you are going to live together, reconcile and live together again as husband and wife?
No, sir.
How many children have been born to you since the date of your marriage?
One,
Okay, and that child's name is?
Jeremy Brian Flores.
And you're asking to be appointed sole managing conservator of that child with your husband appointed the possessory conservator?
Yes, sir.
Give me just a moment.
Yes, sir.
Now, you check that you're going to have a standard possession order, which is attached to your divorce decree.
Yes, sir.
But there's not one attached to, oh, wait, there's other attachments here. Hold on. Is this one of them? All right, so you do have this filled out, never mind. Okay, and you also have said that you would set child support at 0.
Yes, sir.
Why is that?
I feel like we can co-parent better if my soon-to-be ex-husband hopefully will have all of his finances so that he can provide the best living situation for my son while my son is, in his custody. And I just feel that that'd probably be best for him to be able to afford a place where my son can be comfortable when he's not with me.
And you're also saying that you're going to provide the healthcare insurance for your son?
Yes, sir. I have very good insurance that's very affordable through my job.
I need to tell both of you that the law in Texas presumes that every single thing a married person owns is community property. And it's not a matter of whether you're fighting over something. If you own anything that's valuable enough to have a lawsuit over one day, it needs to be spelled out in the divorce decree who gets it. If the divorce decree does not spell out who gets it, then the law presumes that I, the judge, forgot to divide it and that you still own it together even though you're divorced. And years from now, creditors of one of you could go back and sue the other spouse claiming that there's community property that wasn't divided that you have in your possession and saying that they're entitled to a part of it. So I see looks like a camper or a RV of some kind and a vehicle going to Mr. Flores and a residence and a vehicle going to Mrs. Flores. Is that correct?
Yes, sir.
Is there anything else that needs to be mentioned in the divorce decree to divide it up?
Not that I can think of.
No, sir.
And do you think that the way you have your marital property and debts divided up is fair to both sides?
I
Yes,
believe
sir.
so.
And are you asking to have a previous name restored, ma'am?
No, sir.
All right, Mr. Flores, you heard what your wife testified to. Do you have any questions for her at this time?
No, sir.
Is everything that she stated true and correct?
Yes, sir.
Okay, what are your current living arrangements, Mr. Flores?
I live with my dad. And currently looking for a place to put on the RV camper to live out of. And that's where I'm at right now. Sorry, could you hear me?
Yes. And you're good, sir, with you paying no child support and no insurance for your child?
Yes, sir. The work that I have insurance for myself, but it would be way expensive and not as good insurance as Claire.
I'm not
stated.
talking about you putting the child on your insurance. I'm talking about you at least reimbursing your ex-wife for the cost of that.
Oh, sir, if that's what she had put in the lawsuit, I'll agree to whatever it takes to take care of my son and and health if she wants reimbursement. But I'm not controlling what she wants right now, so whatever she wants.
Ms. Flores?
It was my idea. I really do want what's best for my son, and I feel like if he has his money from his job to be able to afford to live, I don't feel like I need his money, and I feel like he could do better to provide for my son if he kept it. I'm okay. I don't need it, and I want my son to be comfortable when he's away from me.
All right, anything else from either side?
No, sir.
Okay, then I will find jurisdiction to hear this matter. It's been on file for more than 60 days. There is an answer on file from the respondent. He's also agreed to the entry of the divorce decree that's been e-filed. We'll find that the petitioner had been a resident of Wilson County for 90 days and of Texas for 6 months prior to the time this lawsuit was filed. The marriage between the parties has become undermined due to a discord or conflict of personalities. There's no present likelihood of reconciliation. There was one child born during the marriage and no other children were born. And are you expecting a child, ma'am?
No, sir.
And have y'all adopted a child?
No, sir.
No other children have been born, adopted, or expected. And I'll find that the proposed orders concerning the child are in the child's best interest, and I will approve them. And I will render the divorce in open court today. I wish all good luck.
Thank you, sir.
Thank you, sir.
All right.
Your Honor, on our bond hearing, we're conferring. We may get this worked out, Judge.
All right, go ahead.
Thank you.
Judge Wilson, we did get Mr. Jeffrey Garcia back on Ovation versus Stephen Rose. I'm not sure if he was able to reach the other party in Osceola.
Paula is working on that right now.
Yeah, good morning, Your Honor. I actually, Mr. Barreto is a contract lawyer for Creole Law Group who actually represents Ovation Services. I was able to email Ms. Amanda Whittaker with the Creole Law Group stating that the court wanted all parties back on the Zoom call. She has since emailed back and has stated that Mr. Barreto will not be available to jump back on the Zoom call. So that's the information as it is right now in this case, Your Honor.
Judge, I am on the phone with his office right now. They're trying to get a hold of him. Apparently he's not working in the office. He is, I guess, working from home. So I've got his secretary trying to get a hold of him.
Okay. All right. Well, I mean, Mr. Garcia's amount that he's seeking is half of what the plaintiff is seeking, and that's the primary case. He's the intervener. So I will ask you to hold on, Mr. Garcia. I'll ask you to hold on, Mr. Rose. I'll find that failing to set your clock ahead Sunday morning is a reasonable excuse to not have appeared at court on time on Monday morning, certainly for a pro se litigant. And I will set aside everything I ruled earlier today. I don't know that a trial will make any difference, but I want to give Mr. Rose a chance to speak with the attorneys and to put on any case he wants to put on. So, Mr. Rose, I'd already taken a judgment against you earlier this morning. We checked to make sure that you weren't outside the courtroom. We checked to make sure that you weren't in Judge Ellison's courtroom. I wasn't thinking about daylight savings time. So I have not actually signed a judgment yet. I will not do so. I've just verbally set aside what I did. I'm going to ask you to stay online for a bit longer. Or actually, Mr. Garcia, is the answer that there's just not going to be anyone here today, or they're just trying to get someone?
The email was quite clear stating that Mr. Barreto was not going to be able to get back on the call, but As far as the interveners taxes, we can, if I could just speak with Mr. Rose on it, we could come to a payment agreement on that. But I can on behalf of Ovation since it's their case.
Sure. Okay, all right. Well, then I'll ask Ms. Poppy to put you into a breakout room with Mr. Rose on that issue. And I will set this for 3:31. All right, Mr. Rose, unless you get written notice that something else is going on, I am going to, because the attorney for the plaintiff has already left and apparently they're not going to be able to come back on, I'm going to reset this case for the plaintiff's part for March 31st at 9 a.m. Actually, that's the criminal date. Do we have a civil date docket that date?
I'm sorry, sir. What was your question again?
That's actually a civil date. I mean, a criminal date, March 31st. When do we, around that time, a couple of weeks out, do we have a civil date in Wilson County?
We could do March 29th. Could you do
Okay.
civil and criminal on that
That's
day?
exactly 2 weeks. So I'll set this for March 29th. If you don't receive written notice of something else or email notice of something else, Mr. Rose, but I'm gonna ask you to confer with Mr. Garcia in a breakout room in just a moment.
Thank you, sir.
All right, does anyone have anything ready to go?
Mr. Anders may. I don't know. Are you there, James?
I am, but I haven't seen that my signed plea agreement has been accepted for when I filed it.
And Judge, this is something that's not on the docket.
That's right. I did it this morning. This is totally like I'm not trying to cast aspersions on anyone. This was just something I thought that I might be able to slip in if it's not too difficult of a docket.
Mr. Anders, I have accepted your plea packet.
Oh, awesome.
I do need to run to the DA's office and get Lorena to re-sign her spots because it's too faint to read on the packet that you filed. So I'm going to have her sign again before I then create it and drop it to the judge. But we do not have a judgment from the DA's office, so they need to be in agreement to this plea and get a judgment ready.
Yes, ma'am.
All right, let me know when y'all have that going.
And Your Honor, this is Adam Anthony from the Medrano case. I uploaded the revised order that conforms with the court's rulings, and I've already conferred with defense counsel, and he's agreed to it.
Okay, I will sign it right now and post it in chat to everyone so you can have an unfile stamped copy.
Thank you, Your Honor.
Can I have the Wilson County Jill please join breakout room 5?
All right, Ms. Kruger, I just posted that in chat, the order on Medrano. I'll just put reset on request.
Okay, Judge, I'm pulling it up now. Thank you.
So, except for possibly the Daniel Ramirez case, that's everything on our criminal side, our civil side, I believe.
That's correct, Judge.
Okay. I'm going to log off in just a moment and reboot my computer. About every third time I try and do something, my Acrobat locks up for 30 seconds. So I'm going to log off. I shall be back shortly.
Can the Wilson County Jill hear me? Hello, sir. I'm needing you guys to join breakout room 5, please.
Jennifer.
Yes, ma'am.
Okay, no on Rodriguez. She did not appear.
Okay.
Okay, so page 1, have we gotten appointments on Gary Wilshire and Joseph Padilla?
I was just confirming with Mr. Rivas that he interviewed both of them a while ago. So no, I have not checked tech share to see.
Well, I looked and I don't see appointments in there yet. Because so those will get appointments today, and then they'll just be reset to the 331 for arraignment. Oh no, that's MTRs. So they don't get 331. Okay. Okay, so at this point, I saw that Judge did appoint Rolando to Melissa Rich.
And Cindy, is she present?
She is not here, but I don't know if after she interviewed, she thought she didn't have to come.
Okay.
So you may want to, have you received your appointment sheet yet?
Yeah, I just got it.
Okay, why don't you try contacting that number real quick right now? And if you can reach out to her, maybe you can get her to sign on. But for sure, she would be down for that arraignment date of 331. But I would like to know if the information that's on that appointment sheet works for you or not. If it doesn't work, then we need to see if there's some other number we can find for her.
Sure. Let me give her a call.
Okay, thanks.
Miss Davis, if you can hear me, will you check your chat?
Who were you talking with?
I was talking to Miss Jean Davis at probation.
Oh, okay, sorry. At the jail, we're needing Mr. Farias and Miss Sotelo next. So go ahead and put you in breakout room 6.
Your Honor. Can you hear me, Judge? I can't hear you. Judge, we're going to drop the setting for today, and I'm going to continue to confer with the state. And then we may get it resolved. If we don't, we'll place it on a docket down the road, but we're going to drop today's setting.
Steve, you just dropped the chat.
Okay. Yeah, I see that now.
Okay, Jennifer, Judge made me the host. Would you like me to make you the host?
Yes, I think he dropped off again.
Yeah, he went back out again. So
When that happens, I think it just picks at random.
all right, let me see if I can. Okay, now he's the host.
Okay, I'm back, and this time I have audio. So,
Your Honor, we're going to drop this setting on this bond reduction. We're going to continue to confer, and we may just get it worked out, but we're not going to have a hearing today, Judge.
all right, thank you. And where do we
Okay.
stand on the criminal cases?
I now have everything ready to go on Ignacio Solis, Wilson County Jail. Are y'all there? Or are they in a breakout room?
Judge, can you have that, give me that ability again? I think they're in a breakout room.
Okay, I just made you the host.
So as soon as they come back, if we can have them bring Ignacio Solis, then we're ready to go with that plea. I am emailing you that packet right now and the judgment, Your Honor.
Thank you. All right, and is Ryan Boyer still on?
I don't believe so, sir.
So he set Mary Lily Amesquita's cases to 2 different dates?
Yes, sir. I chatted with him privately about that, and then he said that he was fine with setting them both for the 3/31.
Okay.
But he did leave the meeting before I was able to ask him to repost.
All right, I'm just gonna put 3/31 here for both.
Yes, sir.
All right, and on Mr. Joseph Padilla, did we get a financial voucher on him?
Your Honor, this is Dan Rivas. Yes, I just finished the paperwork on him and get it sent in. I'll take care.
All right, thanks. Let me go and check that.
And Jennifer, did you check and see if the jail is in a breakout room, or do I need to call them and tell them to log back in?
And on Jose Barrientos, it comes up with Michael Baird as the attorney, so that's good.
Yes, sir, which he was already on that one case. I had Dan add the second case to that appointment sheet. There should have been one offense on it, and so I told Dan we needed to put the, have a sheet for the second appointment.
And I just hit save, so that's done.
Okay, thank you.
So what are we gonna give him, 3/31?
We are setting him with his other case so that they stay on track with each other. So we're going to do arraignment with him on 4/19.
4/19. All right, thank you.
Jennifer, can you hear me? I think she's lost her audio. I've asked her about the jail and she hasn't responded. Jennifer, can you hear me?
Is Devin King too? Yeah. See, he apparently was the only one that.
Jennifer.
worked with them, 'cause he said, "I'll put it up for 1 or 4 years ago."
I don't think her audio is working.
It's not. I'm going to put stop video so she'll look, and if you want to send her a message in chat. All right, and I see where Joseph Padilla is in the attorney requested queue now.
Jennifer, can you hear us?
Cindy, can you hear me now?
Yes.
Okay, thank you.
All right. So my question to you was, is the jail in a breakout room, or are they?
They're in a breakout room, yes, ma'am. They've been in with Kathy Sterling.
Okay. Okay. So once they come out, then I think that James Andrews maybe needed to real quick talk to Padilla. Yes. And then we're ready to go with that plea.
What plea?
Joseph Padilla, add-on of James Andrews. I emailed it all to you, Judge.
Is that the same Joseph Padilla who is on the docket?
No, I'm sorry, not Padilla,
Solis.
Ignacio Solis. Ignacio Solis. I'm sorry, I apologize. I was just looking for Padilla and Tech Share to see if we had an appointment yet.
Hold on, please.
Jennifer, are you sharing your screen or who is this?
Michelle, are you able to take a payment?
No, I'm not. Miss Jean Davis seems to be sharing your screen. I think.
Jean? Jean?
I stopped it.
Yeah, it's the same.
Sorry, guys. We're trying to figure this out. Did it stop?
Yes, ma'am.
Did it? Okay.
Why don't we go ahead and get Mr. Solis's thumbprint and send that to me?
All right, and the card that you're using.
Okay, I will send that one page over to the jail and get them to get a thumbprint.
Taylor Bader, Bader.
The Ides of March.
Your Honor, I emailed the judgment over to the jail to get his thumbprint and also called and spoke to them to let them know they need to get it and email it back ASAP and to have him ready to go for his plea.
Thank you. All right. And Ms. Whitney, Ms. Leday, Mr. Leday,
Yes, Judge.
Yes, Your Honor.
copy of the attachment in Solis, the copy that came back is only partially legible. The state's attachment?
Which part, Your Honor? Oh, just the attachment is,
Yes.
The offense report part,
the
Your
offense
Honor.
report. I can kind of read a lot of it, but for instance, I'm not sure if there's a 22 that needs to be forfeited or.
let me see, Your Honor.
I apologize. I think that may have been my fault. My printer's weak.
And that's fine. It's just
Let me,
every time you print and scan, you lose a whole bunch of detail, and it's just I can't read a lot of it. A good bit of it.
Your Honor, let me go ahead and just email you the state's attachment. Let me.
That's fine.
Lorena, I've got it up. If you want me to just send it to him.
If that'd be great.
That's great. Or just post it in chat and I'll cut and paste it. I see Mr. Wilshire's in the system now. All right, Mr. Rivas, are you online?
Yes, sir, I am. I'm terribly sorry for the delay there. Our office had instituted a change in procedure, and that put me behind.
Okay. Joseph Padilla, he makes good money when he's not in custody, but right now he's locked up. Is there any likelihood he's going to be getting out?
Not to my knowledge, sir. I questioned him about the income. He said when he's working, and he's usually working 40 hours plus a week, he makes approximately $150 per day. So I calculated that as 20 days for the month, which comes out to $3,000. That's the only thing I could calculate.
Mm-hmm.
There is a previous text share also where he was also not eligible.
Okay, that's fine. I'll put a note in the appointment. All right, I appointed TRLA.
On Wilshire?
Padilla.
Padilla, okay.
before it's taken off. I'm not gonna- And were any of those folks that I reported on Judge Ellison's docket, you know?
Sir, I've not gotten to that, I'm sorry.
Okay, that's fine.
Jennifer, did Jason Nitz get a reset date for Vicente Avila? We did check. He is in Bear County.
Yes, he did. Let me find it. He posted 5/18. I'm not sure if he posted to everyone or just to me.
And Lorena or Rolando. Rolando did e-file the plea packet to me, except it does not have the offense report. It's only the admonitions. So if somebody can email me the offense report on those so I can add it to the admonitions for the judge.
Mr. Arguelles needs to get that in a package. Just to interrupt Ms. Sawyers.
Is he?
You offering, but if the defense counsel get it all, and I believe they are getting that, they need to send that in a package so that your office doesn't have to go through and do that. Is he on?
Rolando, are you there?
Yes, ma'am, I'm here. My apologies.
Okay, so the plea packet that you e-filed, can you email me the entire thing, including the offense report? I need the whole packet.
Sure, I will send it right over to you.
Thank you.
Mhm.
Okay, let me know when we're ready to go on this Solis case. As we wait for the jail.
Yes, sir.
Judge, I sent you an original copy of the plea packets. You can read the exhibits. I also just sent you the reports by them. If either one.
I've got them off that copy you sent me.
And Mark, can you send the same thing to me, please? Because I need a copy that will,
I've already attached it.
okay, thank you.
No, Cindy, the
Jennifer, has TRLA given you any dates for any of their clients?
No, ma'am, not yet.
Okay.
Okay, can you hold for just a minute, please? Are you done on? I'm done. There's someone who wants to make payment. What's the last name? 6. Okay.
Your Honor, did you do Gary Wilshire? Was he in there yet?
He wasn't in the where I could do anything with him last time I looked.
Expiration date?
And Melissa Rich, that was appointed to Rolando. Were we going to just do a reset to the 331 on her, or is that going to be called as a nice eye?
Phone number associated?
Is that on Melissa Rich?
Yes, were you able to reach her?
We called the number and no answer. So no, I wasn't able to.
So did anyone give her any notice that she should be here on the 31st?
Yes, sir. She was sent a notice of first appearance.
Not for today or for the 31st?
No, for today. I don't believe anybody has spoken to her because her appointment sheet was filled
Yeah,
out
that's what I thought.
a long time ago. So she knew to be here today. Nobody gave her the 31st.
I think we need to call the nice eye. If Mr. Arguelles can get a hold of her and get her to show up, I'll hold it for until the 31st or 29th, I guess the 31st.
I'll keep on trying, Judge.
All right, and Ms. Harge, are you able to sign documents electronically?
Yes,
Is-
sir.
I believe it varies.
All right, I just posted the verification page to you. If you'll sign that whenever we do this and send it back to me, I will put it into the plea package. Yeah, Gary Wilshire is still in the attorney requested queue. Oh, well, see, he's in the termination queue also. All right, Mr. Hernandez?
Mr. Rivas today, sir.
It's Mr. Rivas. I'm sorry, Mr. Rivas.
Yes, sir.
Okay, do we know why you have access to the determination of, pardon me, the attorney requested queue?
Yes, sir. I'm updating it right now because when I printed out the docket this morning, apparently my printer started on the.
Okay, all I want to know is Gary Wilshire is in the attorney requested queue. He is also in the determination queue. So I'm trying to figure out how that happened and to get you to go in and edit the financial questionnaire on the attorney requested queue entry for Gary Wilshire. Because every time somebody goes in there, that starts the count for our timeliness for appointing running. And if they're in there twice, which happens frequently, in that I have one copy of the offense in the requested queue and one copy in the determination queue, if I approve the determination and then appoint an attorney, there's still that copy back in the attorney requested queue, and the deadline and our numbers for whether we're meeting the statute show that we're not, because it showed that Gary Wilshire requested an attorney today and we didn't give him one, even though we gave him an attorney in the exact same offense. So that's something that we need to monitor. So I'm going to ask you to go in there and edit whatever you need to do to the financial questionnaire queue, financial questionnaire on the Gary Wilshire entry in the attorney requested queue to make sure that it's gone, so that whenever I appoint an attorney, that's reflected in our numbers.
Yes, sir. I'll do that right now.
Judge Wilson, I just ran through those names that you sent Judge Olson and I,
Yes.
and I don't see them on the docket this week in Atascosa for today or Wednesday. I do have a new indictment list. I haven't ran it through that, but
Okay.
I'll do that now, though.
Okay, Jason Nitz, can you hear me?
Yes, ma'am.
Okay, so a warrant recall was never submitted. On that last time in court, let me look at my notes. We issued a certificate of bailiff on 2/24, issued the warrant. And the only note I have after that was from Jennifer saying that we were having a hearing today to recall the warrant. That's what this was today. It says hearing on warrant recall in court today.
Okay, I have a signed warrant recall. I thought we'd agreed to it. I filled out.
Did you have a judge sign it? It never
No,
got
no, it's
through e-file or anything like that. So the warrant stands until it's submitted and gets forwarded to a judge for their signature.
okay. So maybe that was a. Let me see.
Jason,
Mr.
how
Andrews?
you assigned recall on 2/26?
Right, and I thought that was then submitted. I didn't know that I was supposed to submit that. I thought once I got it to you, it would be submitted already. But that's my mistake, I guess. Let's see. Okay, Cindy, can I forward this to you, or should I just put it in chat?
Judge, what would you like to be done? Do you want him to e-file it or drop it into chat for you to have a quick hearing on? Or Mark said it was agreed to on 2/26.
Well, it's already been served. It's too late to recall it now. I mean, I'll be glad to sign that. I think we really need something that says, like, give him a PR bond and then give him a date.
Well, at this point, he's been arrested in Bear County on the warrant, but also for evading arrest.
Oh, so we can just give him a PR. I mean, the warrant's already been served. We can't unring that bell. So I would think it would be better to just get something for me to sign that says he's entitled to a PR bond.
If we do that, then he won't get credit for the time he's serving in Bear County. That's the only problem.
All right.
So at this point,
The time he's serving in Bear, so you're saying you don't want that to happen?
no, because I don't know when he's getting at this point. Eventually, I do want it to happen once he's given a PR bond in Bear County, which usually happens quickly. But if they're holding him on, maybe we can get a bench warrant to bench him out here, and then they can give him a PR bond there.
Okay, but they're not going to give him are they going to give him the PR bond even though he's still being held on the other keys? Or are they going to wait until?
That I don't know, and I'm not his attorney on that one. And
okay,
there, but I can
wrapped
contact.
up an order that says he gets a PR bond effective the date he bonds out on his other charges.
I'll do that. Thank you.
Your Honor, the other one's been deactivated on Wilshire. You should have the correct one on text share now.
Cindy.
Yes.
Did I not see the jail back?
James Anders, I believe, is in a breakout room with his client.
With this client? Okay.
And Rolando, I did receive the first plea packet on the 2009-250. I still need to get the one on the 312 case.
It just finished scanning. I'm about to email it to you.
Okay, perfect. Thank you.
Mhm.
Okay, and I appointed the public defender's office to Mr. Wilshire, so I guess that'll be a 331.
Okay, this is an MTR, not an arraignment. So, I mean, it can go for 331.
Oh, okay, I don't care. Or maybe they can talk to him today in just a minute.
I did.
We're still waiting on the lady from Bernie.
And Your Honor, just so the court is aware, and so Ms. Gibbons has not shown up to probation yet.
Right.
And Kathy Starling. Have you done dates on any of y'all's that Public Defenders is representing? So Wilshire, Padilla, Sotelo, Ferris. Have y'all figured
I haven't put it in the chat yet, but Lorena and I spoke about Mr. Ferris, and we're gonna reset that for 3/22, the next available date for a contested MTR hearing. I have several witnesses for that date. The other Padilla and another name you mentioned, is that specifically under Ryan Boyer? Because I believe that he has private cases.
Okay.
Yes,
no.
I think they're his private cases.
On Amisquita is his private case, yes. But Padilla and Wilshire just got appointed to y'all today, first
Okay.
and third. And then Senya Sotelo's 3 cases.
I am about to speak to her at the jail after the plea.
Okay.
And
Cindy,
I'm sorry.
Kathy, go ahead. Go ahead.
The second one that got appointed to us, not Padilla, but the other one, what page is he on?
The very first one on the docket, Wilshire.
Oh, I see. Thank you.
And Ms. Starling, when you
He's
say,
custody also.
and Ms. Starling, when you say contested hearing, pleading true to any of the allegations?
Yes. There's 2 allegations at this point we'd be pleading true to.
And what allegations are you not pleading true to?
Sorry, is this Lorena?
Yes.
Hey, I was about to send you an email with all that information.
Perfect. That'll work. Thank you.
Excuse me, Judge.
And, oh, Cindy's gone.
I'm here.
Okay. Wilshire and Padilla, are they in custody?
They are both in custody and they're both MTRs.
Okay, so, I mean, I can talk to them.
Okay, I guess when the jail has a room available, then we can put you with them.
Okay, and then or we can reset to monitor for a waiver.
Neither one of these need waivers. These are both MTRs, not waiver of arraignments.
Okay, I'm sorry. Okay, let me confer with the state first then.
Excuse me, Judge. I just spoke to Ms. Gibbons and she's still driving to the courthouse. It seems to me that she's going to make it right at noon. Okay. Thank you, Judge.
I'll be here.
Mr. King Dawes, do you need Lorena or Mark?
Okay, either one is fine.
Who's going to be tied up with the plea coming up?
Lorena, I'll take $15.
Okay.
Thanks.
Okay, I've got to log off. I'll come back as quick as I can.
Cindy, I'm going to step away from my computer for just a minute. I'll be right back.
Okay.
And Cindy, I posted that order. I don't know if it'll be there when the judge logs back on.
Okay, what I will do is I will go ahead and save it so that I can drop it into him. Because if it wasn't posted before he logged out, he's not going to see it.
No, it was supposed to be before he logged out.
Oh, then he'll be able to come back in and see it then.
Can the jail get Ms. Sotelo in the meantime for Ms. Starling? Ms. Starling, if the plea is ready and the judge is like needing to go while you're in the breakout room, I'm going to close down all the breakout rooms and it'll throw you back in the meeting.
That's perfect.
Okay?
Yeah, and it usually gives me 60 seconds warning, so I'll make sure. Thank you.
Thank you.
Okay, are we ready to go on Solis yet?
State is ready to proceed, Your Honor.
All right. Mr. Andrews here.
He had been on the phone, sir.
I got
so.
it. He's asking me.
And is Mr. Solis at the jail? Is Mr. Solis at the jail?
Yes. Are y'all ready for him right now?
I am, yes.
I am.
Okay, I'll close out
Yes.
the breakout rooms. We
Thank you.
had, can you give me the host ability again?
Oh. And Ms. Sawyers, did you get the verification page for me?
Yes, sir, I did, and I saved it. I didn't know if you wanted me to send that prior to him swearing off on his signature, or,
No.
but I do have it, and I have signed it and saved it to add to your packet.
All right.
At the jail in Wilson County, can we please have Ignacio Solis Jr.?
And Your Honor, I don't know if you can see it in there. Jason Nitz dropped in order to reduce bond on Avila.
Every
Okay.
time I have to exit out, all my chat goes away. So
Okay, so I'm going to download it and then drop it back in there to you.
all right.
Cindy, I can just drop another copy in. That's not
Okay,
a problem.
perfect. Thank you.
I'm sorry to interrupt. Do y'all need Solis right now?
Yes.
Yes, please.
Yes, sir.
All right, give me 1 second. I'm sorry.
Your Honor, I don't know if it matters or not. I was looking at the bond that Jason had posted and the amounts he had put there, and that is not what was ordered on the warrant. You had ordered for his Count one, 150,000, and count two, 100,000.
I apologize. Those were the previous amounts. I didn't realize that they had changed. So let me, I can redo
And
that.
I can do it. What are the new numbers?
The new numbers are count one, 150,000, and count two, 100,000.
Murder?
Because he had had multiple nice eyes.
All right, I just posted the bond order in Avila. All right, calling State versus Ignacio Solis Jr. Are both sides ready?
State is ready to proceed, Your Honor.
Defense is ready, Your Honor.
Okay. Are you Ignacio Solis Jr.?
Yes, sir.
Is that your true and correct name?
Yes, it is.
All right. Mr. Solis, can you speak, read, and write the English language?
Yes, I can.
And are you a United States citizen?
Yes, I am.
All right. Despite your representation that you are a United States citizen, I need to caution you, but if that is not true, the plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes, sir.
All right. Do you have any history of mental health problems or mental illness?
No, sir.
All right, counsel, do you believe your client's competent to stand trial?
He is, Your Honor.
Mr. Solis, you stand charged by indictment with the state jail felony offense of evading arrest or detention with a previous conviction. Specifically, it's alleged that here in Wilson County, on or about June 25th, 2019, that you intentionally fled from Officer Henry Farnert, a person you knew was a peace officer attempting to lawfully arrest or detain you. And it's also alleged that prior to that date, in cause number 157129, CRW in the 81st District Court of Wilson County, you were convicted of an offense under section 38.04 of the Penal Code, evading arrest. I need to ask the state's attorney. Okay, so you were convicted on July the 12th, 2016. All right. So do you understand what the state's alleging?
Yes, sir, I do.
All right. Now, that alleges, as I said, a state jail felony, which is punishable by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. So do you understand what the range of punishment is?
Yes, I do.
Do you understand that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
I understand.
Okay. And if I do follow the plea bargain agreement that you have, the sentence I impose is not harder on you than what you've agreed to. You understand you will not be able to appeal this matter.
Yes, sir.
But I want to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Plea to the Court. Let me ask you on paragraph 2.11, is this your signature?
Yes, sir.
And also where it says verification.
Yes, sir.
And do you swear or affirm to me and to the district clerk's office that everything that appears above your signature at verification is true and correct?
Yes, sir.
Did you also sign on the certification of appeal?
Yes, I did.
Agreed punishment?
Yes, sir.
Waiver of preservation of evidence?
Yes, sir.
And the discovery compliance certificate?
Yes, sir.
Did you read these documents yourself, or did your attorney, Mr. Andrews, read them to you?
He read it and I read it.
Okay. Did you understand these documents before you signed them?
Yes, sir.
And are you satisfied with the work that Mr. Andrews has done for you?
I'm very, very, very satisfied with it.
All right, counsel, do you believe that you've received all of the discovery you're entitled to in a timely manner?
Yes, Your Honor.
And do you also believe that your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
I believe that he does.
All right, I will accept the discovery compliance certificate, and I'll find the defendant made his waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And I'll ask you, sir, to the allegation in the indictment, state jail felony of evading arrest with a previous conviction. Do you plead guilty or not guilty?
Guilty.
All right. Has anyone promised you anything other than your plea bargain with the state to get you to plead guilty?
No, sir.
Has anyone harmed or threatened you or anyone close to you for your plea?
Not at all.
All right. Has anyone promised you an early release from your sentence?
No, sir.
Okay, I'll find that you made your plea voluntarily. You're not under any compulsion in making it, and I'll accept it. And I'll ask what evidence the state has to substantiate the defendant's guilt.
Your Honor, at this time, state would offer State's Exhibit 1 and its attachments.
And we have no objection to that, Your Honor.
All right, without objection, State's Exhibit 1 and its attachments are admitted into evidence. Do both sides rest and close at this stage?
State rest and closes, Your Honor.
Defense as well, Your Honor.
Okay, I'll find, I've read the State's Exhibit while we were waiting. I'll find that there is sufficient evidence to substantiate the defendant's guilt, and I will find him guilty, and I'll ask what the plea bargain agreement is.
Your Honor, at this time, we're asking that the defendant be confined in a state jail facility for a term of 9 months, that he pay court costs in the amount of $290, that he pay a police officer fee of $5, that he be given credit for time that he's already served. That is 232 days worth of credit.
That is my understanding, Your Honor.
Okay, all right. Mr. Solis, is that your understanding of what your plea bargain is?
Yes, sir.
Did the state's attorney add anything or leave anything out?
No, sir.
Okay, anything else on either side?
Nothing further from the state, Your Honor.
And Your Honor, from the defense, I would only ask that we be allowed to verify the number of days that Mr. Solis has been incarcerated based on this charge. She mentioned 232 days, and my question is if that sounds correct. 232 days.
Mr. Solis?
from my calculations, I almost had a year done on this.
When was your first date of incarceration?
I wouldn't be able to tell you that.
Okay.
The jail knows, but I mean, I don't have it memorized.
Your Honor, we show days credit as being Mr. Solis was arrested on 3/24 of 2020. He was in the Wilson County Jail to 6/6 of 2020, where he's transferred to Bear County and then brought back here.
I was in Bear County and they brought me here. I was never taken back to Bear County. I was arrested, bonded out, got arrested again, and here I sit.
Okay, so how many days did he have in before he made bond the first time?
4.5 months.
We will happily check on that, Your Honor. That is not what we are showing, but we will check on that.
All right, why don't we just, we've got to wait for our other case, Gibbons anyway. So let's
Yes,
just
Your Honor.
for a moment, let the state check on that. And when were you rearrested in this case, Mr. Solis?
October the 10th in Bear County, and then I was extradited here.
When?
October 10th.
October 10th, okay. All right, so I've been in and out. I've missed some things in chat. Let's see if we can start going over the docket. Gary Wilshire, Public Defender's Office, 331. That sound correct?
Yes, sir.
We haven't been able to talk to him in the jail yet.
Sean King Dawes has posted dates in chat for 331 on Wilshire and Padilla.
Okay. Mesquita, Ryan Boyer in his private capacity, 331.
Yes, sir.
Sotelo, I have nothing.
Your Honor, that is Ms. Starling's case. That is also going to be reset to 331. I'll go ahead and put that in chat also.
Thank you. Ferris?
The same thing with all of those cases.
I'm sorry,
He had to
Sean, Ferris
leave.
is at 322.
I don't see that one. Did you have it with the
Wait,
affidavit?
she sent me a
This is
message.
down
Let me
for
look.
hearing.
Okay, she didn't put a date on Faris in her message to me. So you have
It's
322?
322.
Oh, okay.
All right.
Is that correct, Ms. Starling?
That's a contested MTR. Mesquita, 331 still. Avila, we're going to get a date.
518.
Kevin Lopez, 518. Maldonado, 331. Kevin Lopez, 518. Gibbons, either a plea or a nisi. Arientes, 419. Michael Baird. All right, Bauer, I was given a date, but it was later this month. Will he be out of that ISF by then?
Your Honor, talking to Mr. Flores with probation, he is due to be released on March 23rd. So the March 29th date he will be back at that point.
Okay.
We'll monitor and make sure and see if he is back.
All right. Bierschwal, nisi.
That would be a nice say, yes, Your Honor.
Rich, 331. Rolando Arguelles. And a nisi.
Yes, Your Honor.
Vivian Barrera, Andy Cedillos, and I don't know what date.
I have 331, Your Honor.
Okay.
Yes.
Joanna Rodriguez, no show.
That is correct, Your Honor.
Romero,
Is also a no-show, Your Honor.
Douglas Shields, Roberto Vargas, 331.
Yes, sir.
And Ignacio Salinas, add-on final judgment. Hopefully.
Yes, Your Honor. And Your Honor, just for the court, on the dates, we were showing I know Solis was talking about, he was in for almost 4 months. That would be the 3/24/2020 to 6/6/2020. That would be 75 days. He was then picked up in Bexar County on 10/10/2020 to present, which is 157 days.
All right,
We are also double checking again.
In the first release date in June, that was a bond out date.
That was, Your Honor.
Okay. All right, are those the two periods, Mr. Solis?
Yes, it is.
All right, so do you expect that, are you satisfied that that is correct?
Yes, I am.
Okay. All right then, anything else from either side?
Nothing further, Your Honor.
No, Your Honor.
All right then, I will follow the plea bargain agreement in this case. I found that there's enough evidence to substantiate your guilt. I'll find you guilty of the offense of evading arrest or detention with a previous conviction and sentence you to 9 months confinement plus court cost and reimbursement. Who's the reimbursement to for $5?
It's a police officer fee, Your Honor. It's just a standard fee.
Okay. All right, is there any legal reason why sentence should not now be imposed?
No, Your Honor.
All right, it is the order, judgment, and decree of the court that you be taken by the sheriff of Wilson County and transported to the authorized receiving agent of the Department of Criminal Justice. Your sentence will commence today. It will run concurrently with any other sentence you may be under. And you will receive, be confined for 9 months and receive credit for 232 days served so far. All right, you understand, sir, that because I have followed the plea bargain agreement in this case, that you've waived the right to appeal and you may not appeal?
Yes, sir.
All right, I'll find that you made your post-trial waivers knowingly, voluntarily, and intelligently, and I will approve them and I will certify to the Court of Appeals that you waived the right to appeal and you may not appeal. Wish you good luck, sir. And when I get the thumbprint and the verification, I'll match those in and file these.
Okie dokie.
All right, and Mr. Arwayas, have all the papers been signed up in the Gibbons case?
Yes, Your Honor, they have, and I just received a text from my client. She's still 30 minutes out.
Okay.
And I did email everything to you, Your Honor.
To me? All right, let me see. Oh, I see, 1142, okay. And she has 3 cases. I have 2 plea packets. Is one case going to be taken into account?
One case, Your Honor, was a re-indict, so I have
okay.
dismissal ready to go on it.
Okay. All right. My family's on spring break, so why don't we come back at, let's call it 1:15. Give Ms. Gibbons a chance to get here, and probation doesn't have to wait for her through the lunch hour. And she can check in at 1:15, and they can, if they would go ahead and get her thumbprints and send them to me, I'll match them up with the judgment and then we'll get started.
Thank you, Judge. I'll let her know.
All right, I will see y'all back at 1:15.
And
Judge,
Wilson
can I
County
get with
Jail,
Sorry?
Can I get with the jail on a few things to do breakout rooms for like the next 15 minutes? Is that okay with you?
Do whatever. Ms. Sawyers?
Yes, I needed to speak to the jail. I had emailed his thumbprint page over to the jail. Do y'all have that? Okay, if you will get the thumbprint page and get it sent back to me so I can get it to the judge so he can include it in the judgment, please.
Yes, ma'am. I gave it to the corporal and I'll go talk to him right now, see if they sent that over.
Okay, perfect. Thank you so much.
Yes, ma'am.
Gail, I just need like 3 minutes with Mr. Solis.
Yes, and I'm going to put you in Mr. Sean King Dawes with your client, Ms. Sotelo.
Yes.
So I'll put them in first.
Thank you.
Mr. Andrews, did you already talk?
No, ma'am. I haven't gotten a notification.
Okay, breakout room 10 was opened up. And can the jail see breakout room 10? You may have to hover at the bottom of your screen.
No, ma'am.
It usually pops up on mine as well, but it's not popping up.
No, ma'am, it's not on ours.
Oh, there we go.
There, okay. Yeah, I had shut all the rooms down a while ago. Okay, thank you. Sorry about that.
All right, Mr. Leday, Ms. Whitney, Mr. Arguelles. Hello?
Hey, Jennifer, did you want me to join breakout room 8? This is
No,
Mark.
when I had to open them all back up, it sent all, I didn't do it right. Sorry about that.
I refused it. I figured as much. Thank you.
All right, Mark?
Yes.
Okay, on Haley and Gibbons, I'm trying to look here. The judgment on count 25 on the 2009-250 says it's for count 2. And when I go to the plea package on that count, there is no count 2.
Judge, I think the judgment's wrong on that. The plea pack is correct.
Okay.
We'll just, judgment.
I'll edit that then, and then On 3112, that's the burglary of a habitation? Okay, all right. Okay, so I will make that change.
Okay, thank you.
All right.
Hi, Jennifer, are they supposed to be joining me?
It showed they were in room 10 with you.
All right, let me go back.
You will need to request who you need to speak with.
I would need to do what, I'm sorry?
You'll need to request who you need to speak with.
Oh, okay, with them?
Yeah, they're in breakout room 10 right now.
Okay, I'll go back.
Well, they just got out. Oh. I think they actually disconnected. Mr. King Dog? It
Yeah,
looks like they actually disconnected, so they probably were having some problems.
okay, I'll see them in jail, that's fine.
You'll see them when? I'm sorry.
Oh, I'll see them in jail during the week.
Okay, okay.
Yeah, that's
Sorry
fine.
about
All right,
that.
thank you.
Thank you.
Mhm.
At the jail, the gentleman that was wanting to speak with this client, he actually logged off. Cindy, is there any reason that you see they need to be on still? I think we're done, other than the one.
But Salado, they don't even talk, she doesn't want to talk to her or anything like that?
On Sotelo?
Mhm.
Yeah, the attorney said he would get with her this week.
Okay, cool. All right.
I want to confirm, Cindy, we don't need them to your knowledge, correct?
Not that I know of.
Okay, we
So we're all-
should be good, sir.
We're all done for today?
Yes, we have one left, but it doesn't involve the jail, so thank you so much.
All right, ma'am. Y'all have a good day. I appreciate it. Thank y'all.
Thank
You too, take care.
Yes, ma'am.
that whole stack was only in 2 sheets.
Okay, Judge, I have another one to send to you, but it's not giving me the option right now.
Okay, I had to exit out to reboot my computer yet again. So you may try it again, or have you tried it since I came back?
It's not even giving me an option to drop a file in there anymore. I may need to get out and get back in. Let me do that real quick.
Okay.
Okay, Judge, was the first one I sent you the 250? I just sent the 312.
I'm not sure. And actually, I changed my mind. I don't need those back from you. This is just a probation judgment, so I'll just do it.
Okay, okay. And then
I should have said that before.
Okay, I will send
appreciate
you
you,
the one on Ignacio Solis, Neil.
Thank you. And did we ever get anything from the jail on him?
No, sir, and I think that Debbie's just going to drive over there and get it because they have not gotten it here yet.
No, ask her not to do that.
Okay.
Then they can drive it over here. I mean, I don't know why they can't just scan it.
I don't either. I'm just having issues trying to get anything from him today. Let me call over there and talk to the sergeant and see what the problem is.
All right, thank you.
Hey guys, just want to give you the update that Ms. Gibbons should be at probation office already.
Probation, can you verify that, please?
Yeah, she just drove up. Jean still has to review conditions with her and do the pre-sentence investigation report unless that's going to get waived.
No, I'd like to see one. So just let me know when you're ready.
Okay, sounds good.
Okay. And then I will need the judgment with her thumbprint and address and everything on it so I can send that to the judge.
Yes, we'll try to get it all done as soon as we can. It'll probably be about another 20 to 30 minutes.
That's fine. It's got to be done right.
Okay, thank you, Judge.
Your Honor, while we wait, can I jump onto Judge Brundel's to do a quick plea as well?
No. Yes. I sent him an email. He's probably reading that, but go ahead.
Okay.
Yes, ma'am.
Can we interrupt you for just a moment?
Sure.
Kevin just needed to measure the front of your bench. They're gonna put some kind of bulletproof stuff on the inside.
Excellent.
So-
Go ahead.
Yeah, the good one.
With fiberglass, it's layers and layers and layers of fiberglass.
So what do you?
I'm trying to figure it out. I don't know. I don't want to mount it yet. Probably drill it.
Judge, I sent you the thumbprint on Solis.
Your Honor, just letting the court know that I already finished with Judge Brenda. So whenever the court's ready.
All right, is the defendant ready?
Can you give us just a second, Judge? I'm scanning the stuff to you. I need to give it back to Miss Jean.
Go ahead.
Okay, Judge, you should have both thumbprints for the judgments and the PSI. I just dropped them into chat for you.
All right, let me go ahead and look at the PSI right quick.
Rolando, do you need to review the PSI?
If I could get a copy, that would be great, just to cover my bases.
Okay, I dropped it into a private chat with you.
Okay, are both sides ready?
Defense is ready, Your Honor.
State's ready to proceed, Your Honor.
All right, calling State versus Haley Ann Gibbons. Are you Haley Ann Gibbons?
Yes, Your Honor.
Is that your true and correct name?
Yes, sir.
All right, Ms. Gibbons, can you speak, read, and write the English language?
Yes.
Are you a United States citizen?
Yes, sir.
All right, despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes.
Do you have any history of mental health problems or mental illness?
No.
Counsel, do you believe your client is competent to stand trial?
She is, Your Honor.
All right, ma'am. In cause number CRW 20-09250, you stand charged by indictment with the state jail felony offense of theft. Specifically, it's alleged that on or about April 1st, 2020, here in Wilson County, that you unlawfully appropriated by acquiring or otherwise exercising property over a Polaris razor, the value of $2,500 or more, but less than $30,000 from John Merman, the owner thereof, without the effective consent of the owner, with the intent of depriving the owner of the property. That alleges a state jail felony, which is punishable by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, Your Honor.
In cause number 2011-312, you stand charged by indictment with the offense of burglary of a habitation. Specifically, it's alleged that in Wilson County, on or about April 5th, 2020, that you, paragraph A, and this alleges 2 different ways you may have committed that offense. You intentionally and knowingly entered a habitation without the effective consent of Jordan Powell, the owner thereof, and attempted to commit or committed a theft of property, a firearm, clothing, medicine, an Xbox, and a pair of boots owned by, and I assume that needs to be Jordan Powell?
It should be, yes, Your Honor.
All right, owned by Jordan Powell. And there's paragraph B. It says that with the intent to commit a theft, you entered a habitation without the effective consent of Jordan Powell, the owner thereof. That alleges a second-degree felony, which is punishable by confinement for not less than 2 and not more than 20 years, and by a fine not to exceed $20,000. And by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is in the second case?
Yes, Your Honor.
And from now on, I'm going to refer to the first case as the 250 case and the second case as the 312 case. All right, do you understand, ma'am, that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea.
Yes.
And if I do follow the plea bargain agreement that you have in these cases, and the sentence I impose on you is not harder on you than you have agreed to, do you understand that you will not be allowed to appeal these matters?
Yes, I understand.
All right, there are some documents I want to show you that appear to have your signature.
Okay.
First of all, in both cases, they're titled admonitions to the defendant for plea to the court. And on the 250 case, let me ask, on paragraph 2.11, is that your signature? And can you see that?
It looks like it. I mean, is there a way to, I don't know if I could zoom in on it.
Is that enough?
Yes, sir. I'm sorry. Yes, that is my signature.
Okay.
I actually was using my phone to do it.
I understand. And is that also your signature on paragraph 2.11 on the 312 case?
Yes.
And on that 312 case, did you sign it verification?
Yes. Yes.
And on the 250 case?
Yes.
And on both cases, do you swear or affirm that everything that appears above your signature at verification is true and correct?
Yes.
Did you additionally sign the certificate of appeal on 250 case?
Yes, sir.
And the 312?
Yes, sir.
Did you sign the agreed punishment recommendations?
Yes.
And on the 250?
Yes, Your Honor.
Did you sign the waiver of preservation of evidence?
Yes, sir.
And on the 250, and on the 312?
Yes, sir.
Did you sign the discovery compliance certificate?
Yes, sir.
And on the 250?
Yes, sir.
All right, did you read these documents yourself, or did Mr. Arguelles read them to you?
I actually read through them. I didn't get to read through it all the way. But I did have a question.
All right, ma'am. Well, let me stop you right there and
Okay.
ask Ms. Poppy to place Mr. Arguelles and his client in a breakout room. Ma'am, you should receive an invitation shortly, a little blue box at the bottom of the screen inviting you to a separate electronic room where you can speak privately to your attorney.
I don't
Give
see
me a
the-
quick second. I had to reopen all the, redo it. 1 second.
Okay. I'm sorry. Okay.
We're ready, Judge.
Okay, ma'am. Did you either read these documents yourself or did Mr. Arguelles read them to you? You're muted. Still muted.
Can you hear me?
Yes.
Okay. I read them myself.
Okay. Did you understand these documents before you signed them?
Yes.
Do you have any questions about them now?
No.
Okay, and are you satisfied with the work that your attorney has done for you?
Yes, I'm very satisfied. He did a great job.
All right, Mr. Arguelles, do you believe your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
She does, Your Honor.
And do you also believe that you've received all of the discovery you're entitled to in a timely manner?
Yes, Your Honor.
Okay, I will accept the discovery compliance certificates and find that the defendant made her waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily. And I'll ask you, ma'am, in cause number 250, the state jail felony offense of theft, do you plead guilty or not guilty?
Guilty.
I'm sorry?
Guilty. Right? Yes, because that, well, I'm sorry.
You need to speak to your attorney about that?
If you, yes, please.
All right.
If you click on the bottom, Ms. Gibbons, it says the breakout room should pop up. Just re-click it and then put join breakout room.
All right, Ms. Gibbons, you're muted. Okay. So in the 250 case, to the state jail felony offense of theft, do you plead guilty or not guilty?
I plead guilty.
Okay. And in the 312 case, to the second-degree felony offense of burglary of a habitation, do you plead guilty or not guilty?
Guilty.
All right. Has anyone promised you anything other than your plea bargain agreement with the state to get you to enter these pleas?
No.
Has anybody harmed or threatened you or anyone close to you to get you to enter these pleas?
No, sir.
Has anyone promised you an early release from your sentence?
No, sir.
All right, I'll find that you made your pleas voluntarily. You're under any compulsion in making them, and I will accept them. And I will ask what evidence the state has to substantiate the defendant's guilt.
Your Honor, in regards to both cases, state would offer State's Exhibit 1 and its attachments.
No objections, Your Honor, for purposes of the plea.
All right, without objection, State's Exhibit 1 and its attachments are admitted into evidence in both cases. Do both sides rest and close?
State rest and closes, Your Honor.
The defense rests and close, Your Honor.
Okay, I read over these while we were waiting, and I will find there is enough evidence to substantiate the defendant's guilt on both cases. So are both sides ready for punishment?
State is ready to proceed, Your Honor.
The defense is ready as well, Your Honor.
All right, now I've been given a pre-sentence investigation. Has the defense had a chance to look at that?
Yes, Your Honor, I have.
Are there any objections or additions to it?
No, Your Honor.
Okay. All right, what are the plea bargains in these cases?
Your Honor, in regards to number 2009-250, we're asking that the defendant be confined in a state jail facility for a term of 2 years, but that confinement be suspended and that she be placed on probation for a term of 3 years, that she pay court costs in the amount of $290, crime stoppers fee of $50, that she perform 200 hours of community service, that she attend a drug offender education program, she follow the standard drug offender conditions, that she pay a drug test fee of $50, that she undergoes a drug and alcohol evaluation and follows their recommendations, that she writes a letter of apology to the victim in this case, that she pay a monthly probation fee of $60, that she attend a theft education program, that she pay restitution in the amount of $19,225, that restitution be joint and severally liable between the 3 co-defendants, that she pay a police officer fee of $5, a time payment fee of $15. And cause number 2011 At 312, again, we're asking that the defendant be confined in the Texas Department of Criminal Justice for a term of 10 years, but that confinement be suspended, that she be placed on probation for a term of 6 years, that she pay court costs in the amount of $290, perform 250 hours of community service, that she undergo a drug and alcohol evaluation, write a letter of apology. In this case, Your Honor, attend a theft and education program, that she pay restitution in the amount of $1,547. Again, that it be joint and severally liable between the 3 co-defendants. Pay a police officer fee of $5 and a time payment fee of $15.
All right, ma'am. Did you hear everything that was read into the record by the state's attorney?
Yes,
Is that your agreement with the state?
yes, sir.
Did the state's attorney add anything or leave anything out?
No, sir.
Okay. What sort of work have you done other than working for, is it Godsco Trucking?
I've done a lot of things. It's mostly just taking care of, my family members. And I've just got like ideas that I've been working on to give back to the community. Instead of taking, I want to give back, and it's just ideas that I've got that I've been working on. But other than that, I haven't really been doing much with working. There is programs. Yes, sir.
Go ahead.
Okay.
Go ahead, ma'am. Okay.
I think she was done, Your Honor.
All right.
Wait, what?
All right. And let me ask if deferred adjudication was discussed at all in this case?
Defense counsel requested it, Your Honor, but the state was not in agreement to that.
All right. And Ms. Whitney?
That is correct, Your Honor. The state did not offer deferred adjudication in this case, Your Honor. Just like the co-defendant that pled earlier, this was the theft and the burglary of a habitation occurred within very short time span of each other, with numerous items being taken, and of course the damage that was done to the property of the
Right. Okay.
in the theft case.
If the court wants to assess deferred, we're not opposed.
All right, give me just a moment.
Yes, Judge.
All right. Was Wilson County the county where we had a case where I offered to take time off of the community service hours if a person got training in Microsoft Office? Does that sound familiar?
I believe it was, Your Honor.
You remember the defendant's name?
I believe I do. You've done that on a couple of cases, Your Honor. I just do not remember which case that you did that on with the Microsoft training.
Yeah, the other one was a barber Yeah, the one before that was a contracting license, I believe.
Okay. Because I'm trying to find what I've done before, and I find that if I'd search by Microsoft or by Office or by Word, almost all of these documents were Microsoft Office documents or Microsoft Word documents, and I get a gazillion returns. Let me see.
Yeah, I think in one, Judge, you knock down the font if they did that. The other one, you knock down community service hours.
All right. What are your duties right now, Ms. Gibbons? Where you work for a trucking company?
Yes, sir. Secretary. So,
Okay. What does that involve?
I just still, I do paperwork. I fill out paperwork.
Okay. And is that where employees are coming in? Are people coming in to ask for jobs? Are you keeping track of people's hours? Are you getting permits for over-the-road trucks to be able to go places where they need permits?
Over the road.
Is there any sort of certification or training that you can get in that you're aware, that you know of?
And I don't have that with me or on me, but I'll have to get a hold, and I can get that for you. When do I need to have it in?
I will follow the plea bargain today, but what I'll tell you is if you will come up with some sort of training, whether it's Microsoft Office and or I don't know if there's any certifications or schools you can go to. I know from having relatives who work for, I had a relative who worked for a permit company, and I don't know exactly what she did, but I know that she dealt with trucking companies to help them get whatever permits you need to run an over-the-road truck. I've never done that. If you can come up with some sort of training that you could complete and submit that to your probation officer, I will look at it, and if I approve it, I'll amend the terms of your probation to say that if you successfully complete that, that will take a number of hours off of your community service restitution. You need to do that, but if we can do something that will improve your job skills, that will give you ability to help make the money that you're going to need in the future to pay off all of this stuff.
Okay.
And was there a fine on either one of these?
There was not, Your Honor.
Okay. All right, then. I will, as I said, follow the plea bargain agreements. I will find you guilty in 250 cause number of the state jail felony offense of theft, and in the 312 cause number of the second-degree felony of burglary of a habitation. I'll sentence you to 2 years confinement probated for 3 on the 250 case, and to 10 years confinement probated for 6 on the 312 case, with all the rest of the terms and conditions of your plea bargain agreement with the state. I want to talk to you a little bit about your probation, ma'am. You're a resident of Bernie now? Are you a resident of Wilson County?
No, I don't live in Wilson County.
Okay.
I just recently moved to this address.
Okay. Your probation should be supervised in whatever county you're a resident of, but if the probation officer doesn't believe that you're doing everything you're supposed to be doing, or that you're doing things you're not allowed to do, the probation officer who make a decision on just sending a letter or email to the DA's office to tell them about that and to get your probation revoked will be your local probation officer. You'll have a local probation officer and one in whatever county you reside in. The local probation officer, because they're going to be in Floresville and you're going to be somewhere else, they're not going to have the ability to go by and check up on you. They're not going to be able to go and look at your trash can on trash day and see if it's full of drug paraphernalia or beer bottles. So if they're getting pieces of paper or emails from your local probation officer saying that you're not doing what you're supposed to be doing, they're not going to have a whole lot of choice but to send that on to the DA's office. That being said, the other thing I'll say is that as long as you're being otherwise compliant, if you're not making 100% of the payments that you're supposed to be making here every month, the probation office will work with you on that. By that, I mean, if necessary, you could make larger payments towards the end of the time you're on probation. If absolutely necessary, your probation could be extended, and hopefully your co-defendants will be chipping in and paying at least part of this. What I'm saying is, if a month rolls around that you cannot make a full payment, or any payment at all even, don't fail to go and see your probation officer just because you don't want to tell them you don't have the money, okay?
Okay.
All right, so you understand that because I have followed the plea bargain agreement in these cases, that you have waived the right to appeal and you may not appeal?
Yes, sir.
All right, and I'll find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeals that this is a plea bargain, these are plea bargain cases rather, and that you've waived the right to appeal and you may not appeal. I wish you good luck with it.
Thank you, Your Honor.
Your Honor, I do have a quick question for the court. Are these going to be running concurrent?
Oh, yeah, and there should be just one probation fee at a time.
Okay, yeah, because Ms. Gibbons had that question. I just wanted to clarify that for her.
All right, yes, they'll run concurrently.
Thank you, Your Honor. May I be excused?
Thank you.
Yes, is that all we have?
Yes.
I think that is everything, Your Honor.
think
I
that's
have a
it, too.
note for you, Your Honor.
Thank you, Ms. Gibbons.
We just got a phone call from Kenneth Bierschwal, is the bottom one on page 3.
Yes.
And we just received a phone call from his wife. He is in federal custody, and I've looked up the federal inmate, and he is there in Bastrop County with a projected release date of May 2025. So he's not a nice eye. I don't know what we want to do with that. Lorena?
I've already signed that, but I'll strike a line through it and put set aside, and we'll let the DA's office, what's he charged with?
I don't know what his charge
Okay.
was there.
Yeah, I don't know if that's something they're gonna want to mess with, or 4.5 years federal time is enough.
And Your Honor, on Ms. Gibbons, on that third case, I just e-filed the dismissal on it, so.
All right, thank you. I will look at that in a moment.
Okay, so.
Lorena, was that 251?
Yes, ma'am, it was.
So what do we want to do, Lorena, about Bierschwald?
I need to,
Way out in the future, or?
let me, Cindy, why don't you give me like a week, and then that'll give us time to look at both cases and see what's going on and see if we want to even go forward with our case, since he's in federal custody.
Okay, I'm going to ask Jennifer to then add him to a docket a week or two down the road, just so we won't forget to review him. Jennifer?
And I'm good with that, Cindy.
Okay.
Right, and give me just a moment. I can see Solis thumbprint. Okay, I just wanted to make sure before I cut. All right.
I can add to 322, that work?
322 is fine, Jennifer.
Okay.
Thank you.
Okay, I've just posted the Gibbons plea packages.
Thank you.
And the judgments, and let me insert this on Solis.
there's a release of agreed injunction for the West payment, and then there's another document underneath that. This is an actual suit for an injunction. Petition for injunction. Okay.
And I just posted the Solis judgment also.
Okay, I see it there. And Your Honor, can I ask you real quick? Mark had emailed you lock bombs.
Yes, I'll get that signed in just a minute.
Okay. Thank you.
You're welcome.
Okay.
All right.
Hold on.
I'm not the host, but y'all are excused, right?
Expected a person.
Okay, we'll see folks
Did you get
later.
everything you needed from the posting, Cindy? I can't hear you, ma'am. I think you said yes. Sorry, ma'am, I can't hear you.
Hang tight just a second, Jennifer. This last one is not going where I need it to go. Let me see what the message said.
Okay.
It's saying it cannot open it because it's not supported or it has been damaged. Okay, let me see what's going on.
You may have to email it to you directly when it starts that.
She told me $704. So that's what you're gonna make today? Okay, so 704.
Yeah, I'm gonna have to go ask him to email it because it's saying it's corrupt.
Okay, I think when you start getting that error, there's no correcting it, no matter what you do.
Okay.
And your
Let me go, just have him email